Welcome to another episode of What Does the Law Say? Before we move on, please like, share, subscribe, and drop your comments in the comment section. Thank you. Today's episode will be centered on employment matters. What are the rights of an employee? And what are the obligations of an employer? Our discussion will be based on the Labour Act, the Employees Compensation Act, and other provisions of the law, as well as looking at this situation practically in Nigeria. On today's episode, we have a guest. He's a strategic HR professional with over a decade experience covering total reward strategy, human capacity development, and also HR advisory and consulting. He is the managing partner of Cressida Human Capital Limited, a boutique human resources consulting outfit with an African focus and a global outlook. He has participated in a number of human capacity development and trainings for interventions such as Wema Bank, Andela Nigeria, CAS 45, and Philip Consulting, amongst many others. Welcome with me, Mr. Segun Akiode. Welcome to today's episode of What Does the Law Say, Mr. Segun Akiode.
Thank you so much, Arike, for having me today.
Yes, we're glad that you're here. We're very honored that you were able to make it. Thank you very much.
Thank you.
All right, so right into today's episode, we have some questions we would like to ask Mr. Segun Akiode. He's experienced and he understands a lot about the HR space and capacity development and human resources. So, Mr. Segun, there are many instances and many examples of employees that have, gotten a contract, gotten an employment offer, but do not know how to handle it, don't know what they should look out for. They run off, make the mistake, and then come back and don't know what to do. So as an employee who just gets an employment, what are the things he should look out for in his contract or in his offer of employment?
Okay. Now, for the contract of employment, according to the Labour Act, is expected to be issued within the first 3 months of employment. But most of the time, we usually advocate that never resume or give an employer an impression you're going to resume without seeing the offer.
Okay.
So these days, the usual practice is that you will have seen an initial offer via email that most of the time will not be signed. Just for you to look through what is the offer looking like. Then they would ask you to come and pick a physical copy. At least get to the office and get a physical copy that is signed by the organization that the employee also has to sign off. Now, before the offer letter, there are some preliminary conversations that is expected to have been understood at the point of the interview. Things around how much am I going to be paid, things around the hours of work, things around the location, things around what are some of the benefits that I'm expected to have by virtue of that employment. So at the point of the offer is just trying to add a formal face or more like documenting what has been pre-discussed. Now, where most of the challenge usually come up is you tell an employee is going to earn 100,000. You are not clear whether it's going to be his gross pay or net pay. It is expected for the employee to ask that question before it is signed. That is this gross or net? Basically, your gross pay is without the statutory deduction. When your net pay, which is your take-home pay, is when all the statutory deduction has been made from your monthly amount. So those are issues that usually come up. Employees the offer letter is supposed to have the location of the employer. Where is going to be my primary place of assignment? Remembering that every single thing in the offer letter that you are not clear about and you sign, it's almost like a binding contract. So you need to ask the question, where am I going to be working from? So the employer is expected to be open to say, you're going to be working from number 1 Ajale Koko Street. But there's also that caveat that is usually added to say, if it's a job that will require you to move around, the employer is expected to state in the offer that yes, this is going to be your primary place of assignment, but due to the exigency of work, you may be required to go to other places. That's being clear upfront. The second aspect is how many hours of work.
Yes.
what days of the week am I expected
To be at work.
to be at work. Now, those are little areas that if you get an employer that wants to look shady, they may
Yes.
not disclose, but it's
Yes.
a responsibility of the employee to be sure
Yes.
that it's clear. Now, what that helps you to do is to guide you against the employer changing the rule once you resume. Because if you state I'm going to work 9 to 5,
Okay.
it's expected that I start at 9 and 5.
Yes.
But if it's not stated in my offer letter, as the employee, you should ask. It's your right to ask. You should not look at the employment contract as the employer as being superior to you. Don't forget that this is you agreeing to work for the employer.
Exactly.
Because sometimes some employee approach that from the aspect of, wow, I've been at home for like 5 years, I've been looking for work, I'm desperate, I'm not going to ask questions. I get like, sorry, as much as the employer is deciding, do I want to work for you, it's your right to choose whether you want to work for the employer. So if you see any red flag at the offer letter stage, then you should back out. Because we've had cases of individuals that the offer letters were not signed and they resume.
Wow.
And after we've had cases of individuals that the amount they're going to earn is not well stated. They did not ask and they resume. And it's when they get their first paycheck. And I say, sorry, this is supposed to be net pay. Is that a function of what I ordered and what I got?
Yes.
So those are questions and point of clarification you should ask. It's actually your right as the employee to demand for the breakdown of your salary. Sometimes they tell you when you resume, you will get it. You can actually ask. It's the responsibility of the employer to give it to you or give you an idea of what it is, whether in writing or clarifying. So, because those are usual issues. So if you tell me I'm going to be entitled to a company car, what type of company car?
You're allowed to
Yes,
find out what
you
kind of
should
company
ask.
car it should be.
You
Yes.
should ask.
Yes.
Because I've had cases, you say company car, if you give me a Picanto, if you say it's a company car, it should be clear to the point of telling me, is it a pool car or my own official car? Because there are differences. So when you say a pool car, anybody can use a pool car. When you need it, go and pick it up, go for your meeting, return it. But if it's an official car, it means it's mine. I can take it home. They can give me opportunity to give me a driver to also do that. Simple things around HMO cover. So the other parts that employees should be sure it's in the offer and clearly stated is what's my medical coverage. So statutorily, the employer should make provisions for an health insurance in form of an HMO cover, or some employers do what we call retained hospitals. So they have a retainer with an hospital, designated hospital by the organization that you would have opportunity to go to as the employee. They also state, is there a probational period? For me, is it 3 months before I'm confirmed as a staff, or is it 6 months? Those should be there. It should also be stated, is it a fixed term contract or a full-time employment? It should, the applicants, the employee, the potential employee must also ensure that the type of employment is stated in the contract of employment. Meaning, is it a full-time offer? Is it a fixed-term contract? Or is it a contract for service and contract for employment? So there's a difference between full-time, fixed-term, then contract for service, contract of service. So the contract of employment is a full-time offer. But there are times when you bring in a vendor, a consultant to only work on for a period. We call that contract for employment. So in that situation, the statutory requirement of the law is different. So when I pick payee, for example, if you're on a full-time basis, then you're expected to do your payee to be subject to the personal income tax and the tax table. But if I'm a vendor, a contractor, on a fixed-term contract, for example, at that instant, I am not going to be subjected to the tax table. But what will be deducted from my salary will be withholding tax. And it will still be remitted to the state internal revenue service. But the calculation will be completely different, which means the way I would be treated if I was a full-time employment or a fixed-term contract is completely different. You should be clear what exactly is applicable to you. Am I going to get pension? You should know. The offer letter should state it. Will there be deductions from my salary? What type of deductions? Because it's expected at the point of the offer. And there are interesting, shady ways some employers write offer letters. So they write offer letter, they don't state whether it's monthly pay or annual.
Wow.
They don't state whether it is gross or net. They don't state whether there are statutory deductions.
So is this problem would not only be an employee not paying attention to the terms of the contract. It might also be that the employer has drafted this contract of employment in a way that is not express, it's not explicit.
Yes. So let's be fair to say it's not all employers that do that.
Okay.
But from our own experience and my own experience of dealing with employers, we've actually had cases of, I don't want to say this, but we've actually had cases of individuals that doesn't understand the importance of the contract of employment. And by virtue of that, the employer as well is not paying attention to the content. So they accept any template that is given to them. But because at the same way the employee is protecting his own right, the employer should protect his right. Because if there is an infraction as to what you are not doing, and it gets into the National Industrial Courts, and they notice a missing, something not clear in the offer, the employer is going to get fined for that. Because it means you are not protecting your own right. In terms of risk assessment for you as an organization, you were not clear. It's vague. And once it's vague, it falls back to the labor law. It falls back to international conventions. It falls back to other employment laws that are applicable in such situations. And it means that if you don't cover that gap, then you are open up for litigation. So it's both ways.
Yes.
The employer and the employee.
Yes. So you were stating the other time about having a fixed term contract, and have you had anybody consult you and say, I made this mistake and I thought this was the contract of employment, and then this was what they said, and how were they able to handle it from there on? Okay,
so there's implied parts of you starting before you understand what the terms are.
All right.
Remember, we said the employee must be sure that all the terms of employment is clear to them before they sign. Unfortunately, if you sign before the law, there's no ignorance.
Yes.
So you can't say that I did not see that clause.
Yes.
So in the situation there was a particular situation of an employee that had been in employment for 3 years.
Okay.
The first time the employer gave an offer, they gave them something called tentative offer. And I was saying, which is tentative offer? It's just funny that sometimes some legal individuals, some legal practitioners understand what the law says on some of these things, and they try to go through the lacuna, what is that the word you give it? They see the gap in the law where it's a bit vague, the interpretation is not clear, and they just walk through that part.
Yes.
So the individual came in, never knew that it was actually a fixed term contract.
Okay.
So a couple of weeks ago, she called and said, something just happened. I said, what's the issue? I just discovered that a new management came in and they said that X numbers of set of people are on fixed term contract and their contract have never been renewed.
Wow.
So as a result, they can be terminated.
Wow.
And they even said, since it's fixed term contract, there are some benefit that full-time employment employees have that they can no longer benefit from.
Wow.
So they were benefiting from leave, they were benefiting from some certain statutory requirements, that a full-time staff would benefit from. And the new management came and said, since you guys are fixed-term contract, then you will forfeit. You will still remain in employment, but X numbers of benefits will no longer apply to you.
Wow.
Unfortunately, it's the time is already, it's 3 years. You signed it. You didn't ask the question at the point of getting in.
Yes.
It becomes so the burden of proof is on you as the employee to say whether that clause got in after you signed
or before you signed. Yes.
So that's the conversation, because if the employer can prove that yes, the clause has always been there, it's difficult to prove. It's easier when there are evidences to show that this was flagged, but it was never taken care of.
Okay.
So usually at the point of the offer letter negotiation, it's usually advised that never tilt towards verbal communication. Let everything be documented.
Be written, yes.
If you tell me that it's a full-time contract, let there be an email to show. Let it be in the letter. Don't be desperate as an employee to accept an offer that is unclear and vague as to the terms of the employment.
Yes.
Then the other part is when you resume, there's also the employment handbook or the employee handbook. Yes. The employee handbook is supposed to give you more in details as to the terms of employment. Okay. Because it's very critical if you can establish that there's an unfair labor act. Evidences that will be requested in the industrial court would be 1, contract of employment, 2, employee handbook. If you can prove that what the employer is doing is not the employee and is not in the employee's handbook, the employee has a right to petition. 2, if it is stated in the employee handbook, but it says not in consonance with what labor law and international best practices say.
Yes.
So at that point, you can challenge it in court. So take, for example, the minimum, the labor law, maybe we should be able to establish that the labor law in terms of the coverage, it's for workers and clerical staff, manual related. So for administrative staffs, for professional staff, they are usually bound. The contract of employment supersedes the labor law in that situation. But what the employer must ensure is that it does not negate what the labor law says. So if the labor law says you need to give a contract of employment within the first 3 months, it means you must do that. If the labor law says you have a minimum of 6 days for leave in a year, you must not do less than 6 days. Because at that point, since they are not manual labor, you should do more than what the labor law says. Then your employment handbook or your employee handbook must also be able to be fair enough. Because what the court will do is to establish whether it's a fair labor practice or unfair labor practice, or what we call unjust labor practice. And if you can establish that, then that comes up. So it's very critical that at the point of accepting the offer letter, the employee should have what the minimum standard of the law says. I mean, every related employment laws, even the Constitution of the Federal Republic of Nigeria, understand it. So it's everything are available online. You can actually Google employment laws in Nigeria. What are the things that I should have? Put your own offer letter side by side. Does it have all it needs to have? Because if it's not stated expressly, never take a verbal offer. Never accept an offer of employment that is not signed without the letterhead of the organization, because it can really. So
that's also an issue. You having an offer letter, but then it is not the letterhead of the company.
That's another critical one. Then always endeavor to have a physical copy of your offer letter. A forward-looking organization, every forward-looking organization that is not shady always gives. They would even tell you that the email that was sent to you is not the one you should sign. They tell you to come and take a physical copy of the letter before you resume. So you will go physically to the office and sign. They give you 2 copies, one for you, one for them, and you would state when you are resuming. Am I fine with all the offer? So before that physical offer is signed,
Yes.
there's some back and forth that would happen.
Okay.
So some of those back and forth is you clarifying that all the things that are supposed to be the offer are there. Then you can now sign the dotted line, because at that time it becomes binding
Yes.
on both parties.
Thank you, Mr. Akiode, for answering that question. Don't go ahead to just sign a contract that you're not sure of, that you've not read, that you've not understood. You might be desperate for a job, and so whatever it is that comes at that time, you want to take it. But you need to know that you need to go through the agreement, make sure it says what they say it says, and don't have a verbal agreement. Just like Mr. Akiode said, don't let them just tell you that, oh, this is what you will be getting. This is your number of days for leave. This is your salary, and you run off. Think that I have a job, and you find out that your job is a contract job. It's not even a full-term employment kind of job. So make sure that you understand the contract of employment. Ensure that you read through it before you sign that agreement, before you sign that contract of employment, so that, as usual, we can avoid stories that touch. Thank you very much for watching today's episode. I hope you were able to learn something. So this episode is broken into series. Watch out for the next series next week. Please like, share, subscribe, and also drop your questions in the comment section. If you'd like to follow Mr. Segun Akiode for any other explanations, or you want him to answer any questions, or you also like to learn more about HR and capacity development, you can follow him at Segun Akiode on YouTube. You can also check out in the description for all other links to follow Mr. Segun Akiode. Thank you. See you next week.